I'm going to talk to you about 4 common types of claims that we see in commercial lending practice, which is an area that generates some of our highest payouts. Let's start with conflicts of interest. Commercial lawyers often find themselves in conflicts of interest, particularly in situations involving closely held corporations or where the lawyer has routinely acted for a client or group of clients for many years, or in family loan situations. The ever so popular statement, "I don't need a different lawyer, there's no time or money for that, I trust you," has gotten many a lawyer into trouble. The first question you need to always ask yourself is, who do I act for? You'd be surprised how often I hear a pause on the phone from lawyers when I ask them who their client was. Once you determine that, then you need to make it clear to all of the involved parties in writing, then stick to it. All too often as the file progresses, lawyers stray and end up having dealings with another party. For example, a lawyer who acts for a lender only should never allow the borrower to sign at their office. We also see claims arising from lawyers failing to send a notice under Section 28 of the Property Law Act to a prior lender when you're acting for a subsequent lender. As you know, this is to obtain priority for your client's mortgage over any subsequent advances made by the prior lender under a readvanceable mortgage. Mere registration at the Land Title Office is not sufficient notice. Another area of claims is lawyers failing to obtain proper security as a result of failing to carefully review the lender's mortgage instructions. Some examples include failing to obtain security over all required parcels of land, failing to obtain all requisite guarantees, and failing to obtain required or proper security under the Personal Property Security Act. Now, even if you've acted for a lender for many years, don't assume that the instructions have not changed. The use of faulty precedents is another common cause in this area. Examples include attaching the wrong schedule, resulting in incorrect prepayment privileges, using defined terms in a schedule to the Form B that aren't defined in the filed mortgage terms, and including incorrect interest rates, terms, or payment amounts on the Form B because a prior precedent was used. Always use a fresh template when preparing a Form B mortgage. Do not do a cut and paste from a previous transaction, as inevitably you will forget to delete or modify terms, and needless to say, do a thorough review of the document before it is executed.